Move to this now. Public Protector Mkhwebane is welcoming a High Court ruling that agreed with some of her arguments. She challenged the constitutionality of Parliament's rules for the removal of Chapter 9 institution heads. The court agreed with 2 of the 12 points raised, and it found that she should have been allowed legal representation. It also said that a judge should not have been appointed to the independent panel. Mkhwebane is now calling on Parliament to restart the process with amended rules. Let's discuss this with the spokesperson of the Public Protector, Oupa Segwale. Oupa, thank you so much for making time. So what we are hearing from this judgment yesterday is that, number one, the court finds that the Public Protector should be allowed full legal representation, meaning whoever is there to represent her must be able to participate in that committee. But number two, they have raised issues with the involvement of a judge in that independent panel, which found that there is prima facie evidence for the Public Protector's removal. You have responded as the Public Protector. What process do you think needs to be undertaken by Parliament going forward?
Thank you, Clement. I'm glad that you capture the issues quite correctly, because what you've just said now flies in the face of all these claims that have been made out there that the Public Protector's application was dismissed, when the opposite is true. I mean, if you look at paragraphs 99 and 118 of that judgment, it can be clearer than that, where the court held that the applicant, being the Public Protector, achieved substantial success in respect of legal representation, and that litigation in this regard was warranted, even if that was her only complaint. And those are the words of the court itself. And then it further indicated at paragraph 118 that the application succeeds only to the following extent, and then they list those 2 grounds that you have just indicated there. But to get back to your question, what needs to happen going forward is for Parliament to go back to the drawing board by fixing the rules. In other words, aligning the rules to the judgment as it is right now. And then once those rules have been fixed and have gone through all the processes of approval, then Parliament can carry on with the process. But one of the fundamental things that will have to take place is the reappointment of a 3-member panel, this time around without a judge participating in that process. And that alone suggests that the report that Parliament already has, which was prepared by the previous panel, falls off. And any other process that has flown from that particular report must also be halted and be started afresh in terms of the report that will come from the new panel. So
the court agreed with the Public Protector on 2 of the 12 prayers. What were the other 12 points that the Public Protector was seeking in the court that she wasn't successful in?
Well, there were several other grounds which were pleaded in the alternative. In other words, the main relief that was sought is what was granted by the court yesterday. But all the other grounds, which includes the right to audi earlier on in the process, or the right to be heard earlier on in the process before the Speaker engages anybody else, things such as double jeopardy, things such as conflict of interest by some of the members of Parliament who have had unkind things to say about the Public Protector, and yet they are put in a position whereby they must bring an objective mind to this process. Those are some of the things that were pleaded in the alternative, which the Public Protector did not necessarily succeed on. But we are happy that the Public Protector succeeded in the main relief that she sought.
So Parliament has sent out a statement yesterday that they're still studying the judgment and their legal teams will advise on what to do now. Do you think the court should have perhaps been clear on, I suppose, make an order on what process should follow? Because there was no order as to whether or not the process must be started from scratch. But you have indicated, as the Public Protector's Office, that by merely saying that the judge shouldn't have been involved in that independent panel, which was looking at whether or not there is prima facie evidence for the public protector's removal, by merely the court finding that, then it means it's back to the drawing board? Or could it have made it much easier then for the court to order that the process starts afresh, given that they have problems with the involvement of the judge in that independent panel?
I suppose you could say that, but other people would say it's as clear as daylight that if we are saying that the panel that was appointed by Parliament was appointed illegally, it follows, therefore, that anything else that flows out of the appointment of that panel, including the work it did, the report it produced, and what that report has led to up to this point, falls off. And that immediately tells you that they would have to appoint a new panel. But before appointing a panel, they must first fix the rules, which have been found to be defective in at least 2 points.
So if Parliament goes back, fixes the rules, they change the rules to allow for the public protector to have legal representation that can participate in that impeachment process, and they start a process, and compile an independent panel that doesn't include a judge, and then we get back to where we are now, where that committee is supposed to start its work. The public protector doesn't have any problem as long as these 2 matters are resolved. She's committing to present herself before that committee and give her side of the story.
Correct. The public protector has always been willing to be held to account by Parliament in terms of Section 194 of the Constitution. From the very beginning, she has indicated that she is keen to clear her name in this process. All that she complained about was the unfairness of the process on the basis that the rules fall short of what should be constitutional. So once all of those things have been cleared up, the public protector will be more than willing to participate. In fact, she has been participating even when Parliament ran that process, while being aware that there was a court challenge in that particular respect.
All right. Oupa Segwale, thank you so much for your time. A commitment there from the Public Protector's Office that fix up these issues, and then I will come and answer. That's the spokesperson for the Public Protector, Advocate Mkhwebane.